regular meeting of the Ross Valley Sanitary District. The first order of business is the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, Greg.
Director Borstein.
Yes.
Director Silla.
Here.
Director Nichols.
Here.
Director Egger.
Here.
Director Gaffney.
Here.
All present.
Item 2 is approval of the agenda. Are there any corrections or additions or deletions?
I would move to approve the agenda as distributed. See if there's any comments.
I second that.
Any comments from the audience? No. Any further discussion? All in favor? Aye. Opposed? No. Thank you. Now is the open time for public to raise items that are not on the agenda or for future agendas. We're asking that you limit your comments to about 3 minutes. We'll time it, but if you have to go a little over, that's fine. And the board cannot hold any discussion at this time, so we cannot comment. So, is there any member of the public who would like to make a comment? Yes.
Yeah, my name is Nancy Okada, and I was at your last meeting, and I just want to reiterate that I would like to see the lawsuit daylighted. Basically, that the comments and discussions regarding the lawsuit in CMSA and the Ross Valley Sanitary District be held in public at public hearings and allow public input as well. It is our property. We are paying a lot of money. We have rate increases regularly that are substantial, and I believe it's the board's duty to allow us, the public, to know what is going on. I also understand that other jurisdictions have allowed the public to be in on legal discussions, and so there are various precedents that would allow it. It is a public board, it is a public land, public trust, and I think you would do your own board a great service if you, in fact, would have those hearings and deliberations and discussions about the lawsuit in time. Thank you.
Thank you. Anybody else? Yes?
Yes, it's on.
It's also that.
I just wanted to say my name's Denise Beck here. Denise Beck, can you hear me?
Yeah.
Okay, I'm Denise Beck.
Now we can.
And I just wanted to say I hope that the board will vote no on the resolution to issue a CMSA refund revenue bond for 3 reasons. My first reason is there's a poison pill in that resolution forcing Ross Valley to settle a lawsuit. The lawsuit's in the interest of CMSA. It's not in the interest of Ross Valley Sanitary. Okay, that's a public asset. That's the second reason. It's ratepayer owned. It's not up for sale. I resided at Ross Valley District. I have many family members who reside there now. This is not up for sale. It's a public asset, and it's not in our best interest to let you take it over. The other is it will help facilitate, and I know you guys are denying it, but it's the truth, the ABAG and the supervisor's agenda to implement a huge development project in San Quentin called the San Quentin Vision Plan. 3 years ago, we were fighting this with the supervisors in their at the Civic Center. It's live, February 4th, 2012. You guys should watch that footage. Katie Rice should not be negotiating backroom deals. That's a conflict of interest. Someone who's totally behind the development and now negotiating this poison pill deal. But if Ross Valley insists on voting on the resolution, Board Member Gaffney should be recused from voting because it's clearly a conflict of interest. You're voting for a resolution in the interest of your client. Your client is CMSA. You're making thousands of dollars from CMSA. You should not be voting on this. You should recuse yourself. And I will tell you something. I don't care what the lawyers say. The public will not recognize your vote. okay? The public will not recognize your vote. It's a conflict of interest. Do you get it? We're not going to recognize your vote. So recuse yourself now. Thank you.
Thank you.
Carol Page, Sleepy Hollow. In his campaign, President Gaffney said, "My aim is to bring the district back to respectability and regain the trust of our sewer ratepayers. Disregard for the appropriate conduct of this special district does neither. The purpose of the special district is to provide focused services, not an opportunity for its directors to circumvent the public protection laws that are intended to prevent bias, collusion, and corruption."
Thank you. Yes.
My name is Laura Ethel. I live in Larkspur, and I'm a ratepayer here, and of course, also with Central Marin Sanitary Agency. I am dismayed with the public discourse about the settlement of the lawsuit. I think it is in the interest of all of us to settle this lawsuit. And I would personally be satisfied with probably a significant range of possibilities for settlement. Because whatever happens in a settlement, 50% of what happens to the Central Marin Sanitary Agency is what happens with the Ross Valley with this agency, because it's a joint power authority. And the public discourse about this is so full of misinformation, I am really quite dismayed about it. Starting with a statement made by board member Egger that this has to do with housing at San Quentin. Now, when the prison gets torn down and housing is built at San Quentin, probably we'll all be dead. And I know you can still plan ahead, but this has nothing to do with settlement of the lawsuit. Settling this lawsuit is in the best interest of both agencies. The existence of this lawsuit is a reflection of the mismanagement that went on in this agency in the past. And it is not my job to micromanage that settlement, but it is the job of the ratepayers to hold you accountable and the Central Marin Sanitary Agency accountable for making a settlement that makes sense for everybody.
Time.
Okay, that's enough.
Okay, thank you.
I'm going to be watching to see what you do.
Thank you. Yes.
Yes, my name is Mimi Willard, and it seems to me this all distills down to something very simple, which is that presumably you are negotiating in the best interests of the ratepayers of Ross Valley Sanitary District. Taking that as the premise, it would seem that there would be no problem bringing any potential settlement agreement before the public, not for a vote, but just so that people understand what it is that you're voting upon and have an opportunity to express an opinion about it prior to your having the vote at the board level, so that you can solicit the feedback of the community, and the community may disagree, but I think that that would be the appropriate way to proceed, particularly since there is a negotiation with other entities, some of whom are defendants in the lawsuit that Ross Valley Sanitary District has won. Thank you.
Thank you very much. Next. Yes, sir.
Michael McIntosh, excuse me for being late. Traffic is just enjoyable out there, which we'll see with the increase of things going on. The reason,
please.
Michael McIntosh. The reason I'm here is to echo so far what I've heard twice. We as your constituents, we as your ratepayers, pay you to guide us to make a proper settlement. Generally, in the course of law, a settlement includes a release of any and all claims, known and unknown, and things like that. And what the general public would like to see, that I've now seen in writing, I've heard orally, is that we'd like to be part of those discussions to see what is and isn't vetted and what is and isn't accepted. Outside of that, there's also legal precedents that requires you to do that before you make a decision. If you review the language of the Brown Act, it actually tells you that you can have any closed session, a few closed session purposes for discussion. But outside of a direct employment-related issue, you are required to tell the general public before any decision takes place that you're going to have an expenditure of public funds that can include staff, counsel, direction, or in this case, a potential financial settlement and or loss before the general public gets to weigh in on what those assets are that we're giving up, as well as what future liabilities we may be incurring. So I feel very comfortable saying that I believe I can challenge any decision this board makes if the board does not want to include the public in their decision. And I'm not saying that the decision is right or wrong. I'm not even saying that I have the full scope of information to make an educated decision on what I think is right, my sole opinion. But I think that I would certainly be in the majority saying that we, which you would be at the same time on a different table, would like to know what's going on. And for me personally, I think it is prudent to review these decisions. When I reviewed my Ross Valley Sanitation District property tax statement last year, I called it Julie Beal, or Blue, excuse me, who was very nice. And within 3 days, I got a check back for $12,000. You guys overbilled me, and you still owe me more money. And I had to push this for the individual rates, the way that you have the smallest apartments you can build. I guess there's a small incremental difference now at the same as a large mansion with 12 bathrooms. You're forcing the people that can serve out of necessity to subsidize these larger homes. So should we have an insight, a view, and a statement for the direction of this district? Absolutely. I would like to see a true per-use basage or a flow rate basage as San Francisco and Mill Valley have participated in. But above all, it would be wrong for this board to make a decision that expends our finances or our time without allowing the public to see and review. Thank you.
Thank you.
Hi, Joan Bennett from Kentfield. I want to join with Michael in his statement. There is a lot of information, possibly misinformation, circulating regarding why we're here today, and I think it would be in your best interest if you shared with us actually what is going on. That doesn't mean that we're privy to attorney-client privilege information. However, at any time, the client may waive the privilege, and you may tell us, if you choose to do so, what the potential terms of any settlement may be. And we've been burned in the past by settlements by this district, and we don't want that to happen again, and I think that's why a lot of people are here. What I also want to add is that I understand in October of last year, and I mentioned this in a letter that I sent, that the defendant's motion for summary judgment was denied by Judge Wickham in Sonoma County Superior Court. Prevailing on that motion gives you the upper hand in this matter from now on. And while I know that the argument's always made that we should cut legal expenses, that we should cut this lawsuit now by terms of settlement of some sort, at this point you have the upper hand. The judge has all but told you you've got a case, go to trial, their evidence supports your contentions, there are material facts in dispute here, proceed with the lawsuits. You have the upper hand, there's no reason for you to cave in at this point. And I would urge you, as Ms. Beck has stated, Director Gaffney, to recuse yourself. You may have received written opinions, legal opinions regarding whether or not you have a potential conflict of interest or not. Whether there is a real conflict or not is almost beside the point right now, because the very appearance of a conflict will cloud any public trust in what happens in this suit from here on out. It's just reality. You may not like it, but that's the way politics is, and it's something that you'll never be able to outrun ever again because these accusations have been made. So in your best interest, as well as the ratepayers, I think that you should recuse yourself from voting on any potential settlement of this lawsuit. And that's not only on the terms of the settlement and any potential settlement as well, but anything that may in any way affect the settlement, and that includes possibly item number 4 on the agenda tonight regarding the bonds. If you are cashing in the old bonds in effect so you can get lower interest rates to float new bonds, make damn sure that the language of the current bonds that you want to float does not contain any assets that were used as a basis for determining the value of the 2006 bonds, and that would include any equipment that you may own over at San Quentin, and any of the infrastructure, any of the revenue streams that you may have been receiving over the years that go into the value of the district. Because if you've got 2 sets of bonds out there, one of which was included, what I just mentioned, and the other one implicitly does as well, that by the settlement you give all those assets away, you're in effect selling fraudulent bonds. So don't go down that road either. So that's all I have to say.
Thank you.
Okay, may I speak on behalf of Bosch's thing? Just have something that we...
Real quick, because...
Okay, certainly. 2 things. To what Joan said, California Civil Code Procedure 1717 allows prevailing party reasonable attorney fees. They are entitled. So if you have a position of being the prevailing party for an injunctive or financial release, you are entitled to those attorney fees. Second, if you review the Sarbanes-Oxley law as a financial disclosure, even public bonds from any public entity, if you release fraudulent, financial, misstated information, directors of the board may be held personally accountable if she's brought something up. If it's inconsistent with your 2 bonds, you have a personal liability that you're exposing yourself to. Again, all these things can be averted if you just take a moment to let the public see and review. If the public's not here, that's okay. But the public that's interested, please don't preclude us. Thank you.
I'd just like to point out that the Sarbanes-Oxley Act doesn't apply to an entity like this.
I couldn't do that, didn't we?
The Sarbanes-Oxley statute you just referred to.
What'd you say?
The Sarbanes-Oxley law.
Sarbanes-Oxley
Oh,
It's all
statute, it does not apply to public entities.
no, thanks.
Okay, you can get legal advice on this subject. And on another somewhat related subject, I'd just like to say that one person has said that members of the board have not seen pleadings. And if somebody on this board or Central Marin Sanitary Agency who's responsible for a decision has not seen pleadings and they feel like they need to weigh in on this, by all means, take a look at those pleadings. You are violating your responsibilities if you don't get the information you need. And it's your fault if you don't, not ours.
So, okay, just
I have
20 seconds.
I have one quick question. I'm curious, what is the objection that you have to transparency and sunlight regarding the settlement? Why is that not in the public interest?
I didn't say why.
Well, okay, we really shouldn't have a discussion between the public. Let's make your points. Anybody else have a comment?
Nobody left.
I guess I have to know.
You haven't something.
Hi, I'm a ratepayer. I'm here. I don't belong to a group. My name is Rebecca Silla. I've lived in the Ross Valley, been a ratepayer for 25 years. And I'm here because I've been dismayed by the tying between the lawsuit and the potential for construction, because I think it's clouding the issue. And I know how hard it is to sit on a board and to make tough decisions and to have a fiduciary responsibility, having sat on boards myself. And so I just want to say that I'm here to listen. I've been trying to read and pay attention, but I feel it is a disservice to the ratepayers to try to make a suggestion that there is a connection between this lawsuit and condos going up at San Quentin. I just think that's a distraction. So I wish you well in your deliberations. And I wish I could speak as eloquently as everyone else here, but thank you.
Okay, thank you. Anybody who hasn't spoken would like to? Okay, I think just about everybody has spoken. Thank you very much. Now we're on to item number 4, adopt resolution number 1489 regarding the issuance of Central Marin Sanitation Agency refunding revenue bonds to the series of 2015. Greg, you have a report?
Just very brief. So this was an item that was continued from the February board meeting, and it was continued to bring back based on direction that was provided in closed session and is reflected in the staff report. So the only change in the resolution that we had before you before was, and as folks I think have already noted, it's that we added some language addressing the efforts at the settlement agreement of the bonds. And let me back up a little bit because that's
Excuse me, point of order.
Yeah,
Do
go
you
ahead.
have a copy for the public for the change made?
Well, we have the current board package, Pam,
Yeah, but
is
the
available. And I can certainly point it out to anyone that does not have a copy. But
That
let me,
was,
yeah, let me
that was
back.
the email you sent?
No, I'll point out the item, and if anyone doesn't have a hard copy, we can make you one. So just for context for everyone, because we actually did not discuss this at the February meeting, and I wanted to provide some background. So in 2006, the CMSA agencies collectively, the Joint Powers Authority, agreed to issue, I think it was approximately $65 million in bonds to fund a major construction project at the CMSA treatment plant. The purpose of that expansion or improvement of the plant was to handle the wet weather flows that come from the collection agencies and to allow the system to be able to treat those flows in accordance with the newer regulations and the permit requirements under the NPDES requirements. That work was all completed. Those bonds were all expended, and the agencies have been steadily paying on those bonds. And now that at this point in time, starting about roughly 5 months ago, the agencies started a dialogue on the possibility of refinancing those bonds due to the relatively historic low interest rates in the market. So CMSA is the lead agency in that effort, but the member agencies each have to support and pass resolutions in support of that action, obviously. But that's sort of the context of this whole thing. And with the refinancing of the bonds, the agencies are looking at fairly significant cost savings to the ratepayers. For the Ross Valley Sanitary District, the estimated savings are approximately $300,000 a year, and those savings will occur basically for the next approximately 15 years during the payoff of the remaining payoff period of the bonds. So that was the reasoning behind the bond issuance in the first place. Now, as I think has been pointed out, everyone's aware that process has gotten a little bit entangled with the lawsuit and the resolution efforts. And at the direction provided at the last meeting, we added what I'll refer to as, if you'll turn to your board packages and go to attachment B to the item, that is the resolution that you're actually considering this evening. And it is the same resolution, again, nearly identical as to what we had last month. The main difference being Section 5, which is the very last section of that resolution. And what Section 5 did was it added language linking the effective date of the resolution to achieving the settlement agreement. And the idea, again, that was based on direction received in closed session, so I can't really go into any more detail than that. That's what you're considering this evening. Passage of the resolution by each of the agencies is necessary for the bond issuance to go forward. If the board does approve the resolution or a modified version of the resolution this evening, you're authorizing the CMSA to go ahead with the bond issuance, and Ross Valley is committing to backing up that bond issuance. That's really it. I think it's there already. If you haven't seen it, I would encourage you, when you have a chance, to take a look at the CMSA board package for tomorrow evening. It has a brief write-up on the same item and provides a more comprehensive set of information on the financials for the bond issuance. But that's everything in the staff report at this point, so I'll hand it back to the board.
Okay, board members, any comments or questions?
I think it might be appropriate at this point, as we all know, that there have been some investigations by the VA, by the FPPC, and most recently, at our direction, an independent counsel to, I'm not sure the wording, to do a study and findings on any possible conflict of interest. And we did receive that today, and I've been told...
I have a point of order. I think that's confidential information.
I actually, well, Pam,
I think it said that in the email.
It did, and this afternoon, I spoke with our attorney, Andrea Clark, who said that if the five of us would like, collectively, to release the short form of that, which Greg has copies of here, that we could do that to the public without breaking the confidentiality at this point. Am I correct? Is that what Andrea told us?
That's the guidance that we received as of late today. So it's strictly up to the board, but if you choose, you can release a very limited portion of information to address the concerns with the conflict of interest. That is up to the board. And you would need to approve doing so. I think it's basically by voice vote.
Is our council...
Yeah, and Andrea Clark, are you on the line?
I have a question.
Oh, go ahead.
I am. Yes.
Andrea, you there?
Michael Orson is correct that it's the board's decision as to whether to release the short form of analysis that was provided on this particular topic, on whether there's a conflict of interest that would impact this particular decision on the resolution. Where I would make a minor correction to what Mr. Orson said, you actually would be waiving confidentiality for what you allow to go out to the public, or to the board choose to do that. It's the board's decision on whether to waive confidentiality for that particular document.
And Andrea, is there an order problem with the fact that we're talking about the lawsuit when the item is actually about the resolution on the bond refinancing, or is there a connection? Close enough connection?
Well, I think that it's arguable that there's a connection. I think it's a pretty slim connection, and it's my understanding that at least what Michael was just raising was the possibility that the board would release the outside attorney's opinion on the resolution matter only.
Is that correct?
That's my understanding, is that some mention has been made that Director Gaffney should recuse himself from this decision.
I see. Okay, I misunderstood. Thanks.
Yeah, Andrea, we've already set our agenda for tonight. This is not on the agenda to open up confidential information on President Gaffney's outcome of what. Wait, let me finish, Andrea.
I do think that to the extent that the board is interested in addressing the conflict issue on this particular resolution only, then it would be appropriate, or it would be inappropriate for the board to make that decision on this particular item. I think it's a little questionable, and it would be a little bit of heartburn for the board to decide to
I've never seen this ever.
To another decision, such as settlement of the litigation. But for what's before the board right now on Gaffney has a conflict for approval of this resolution tonight.
Okay, so my next question is, in reflection on if a board member has another independent study done or with another, research from an attorney on a questionable whatever, are you saying that the board then can say, well, we've decided we want to open this information to the public? Are you saying that we can do that at a whim?
Not at all. If Mr. Gaffney has hired his own personal attorney, then it is not the board's decision at all on whether any of that information that exists in a confidential way between him and his attorney, whether that's exposed to the public. That is not the board's decision.
Okay, I don't think it's appropriate, but.
Well, the board member raised a question about my conflict of interest, and we hired an independent, I had nothing to do with it, but the board hired an independent attorney, and people are accusing me of things, and if we get an opinion, then I think it should go public. You're for transparency. You've been talking about it the whole time. Why hold back on it?
Thank you.
And you folks have been asking for it too. So, anyway.
A comment from myself, if I may make a comment. Since we have to waive confidentiality, I support full public disclosure of the total opinion, rather than just piecemealing it out a couple pages today and a couple pages next week and a couple pages the following week. I support full public disclosure. It's easier. Since we've already waived confidentiality.
Council, how are the couple of pages, or how are the amount of information? I don't think it would be possible that we would have a couple of pages this week, a couple of pages next
3
week.
memos.
Okay, so how is the information contained in this is the first I'm hearing of this. So how are the pages that were going to be that could be made public chosen?
There's a separate opinion.
I didn't hear the question very well. Can you repeat it, or can somebody repeat it?
Sure. What was the process to determine what could be made public in this memo? Is it just to protect other issues that we wouldn't want to waive confidentiality on?
Well, I think the board needs to think about what it wants to waive confidentiality on. It's my understanding that the board has before it a narrow, limited, two-page plus one paragraph opinion on the specific issue of whether a vote tonight on this resolution only presents a conflict of interest issue with respect to Mr. Gaffney. That two-page document, should the board decide to waive it, could be waived in its entirety. The board could decide in the alternative to waive only its conclusion and talk about it. I suppose this is an unusual set of circumstances, but I just want to reiterate that what I don't think, unless the board tells me otherwise, what I don't think is being suggested right now is that the board vote on whether to waive the privilege on an opinion related to the settlement agreement, which is not on tonight's agenda.
That is correct.
As I understand it, on tonight's agenda is the issue of the bond issuance. And it has been suggested by many, not only here eloquently, but also in the news recently, that for that purpose and that purpose only, Director Gaffney should recuse himself. And I believe that the short form of that document, which Mr. Norby holds over here, if we wanted to, we could make that available in the interest of full transparency, because that was completely an independent. You may not agree with it, but we did everything by the book. And I suggest that in order to hold the talks we're going to hold tonight publicly, that document be released. And that's what I'm asking. It's in this very narrow piece of information.
I think you should open it up to the public to discuss it. If you have a motion, then that's
not on the agenda, so maybe you should.
Well, the only reason I talked about it, Pam, was because it is on the agenda in the form of that we need to make opinion, we need to form an opinion collectively, and I think that if we don't let that information out, many of our constituents here would believe that we're doing something behind closed doors, when in fact, we have this document from an independent counsel, which we all received earlier. Anyway, I would suggest that we, in the interest of transparency, would move forward with what Andrea said and release the short form of the document, which pertains to this very narrow portion and not to the lawsuit, which is not on the agenda. Anyway.
Thanks. Any more comments from the board?
I really think we should open it to the public. I agree with Pam. If we're going to give summary that you can't pick and cherry pick your favorite points, why not just let us see the entire decision about why you don't think Thomas Gaffney is experiencing a conflict of interest by getting paybacks from CMSA at the same time voting on the best interest of his client.
I'm sorry, did you say Tom is,
I think this whole...
he's getting kickbacks? Was that the word?
His client is CMSA, so there's a conflict of interest.
Not for more.
I'm just saying,
Okay,
I agree with Frank, release all of it so you're not cherry picking. Because I'm going to be honest, I don't trust this board anymore after what's been going on. So I'd like to see the entirety of the decision so we can come to that decision whether there's conflict of interest or not. And hire our own attorneys.
If I may, I would like to actually define that kickbacks is probably not the best word to use.
I think there's a kickback, and his client is CMSA.
No, I understand,
CMSA
but
is his
just
client.
sometimes when we have a word that can be improperly quoted somewhere, it can taint a conversation, not get us to where we
I
want to
hear
be.
you.
So I'd just like to
Completely. I'm sorry,
reconsider that one word.
it's a mis.
Yeah, I understand.
But I meant his client is CMSA. He's getting thousands of dollars from CMSA, and he's voting on behalf of his client. So there is a conflict of
No, I
interest.
understand.
Putting aside various allegations and suggestions and just trying to maybe distill this down to something that could be profitably moved forward on, it seems to me that there is an oxymoron here that which is a narrow full disclosure. I support the suggestion that Director Borstein is putting forward that there be disclosure, full disclosure of the entirety of whatever legal input you've had regarding conflict of interest. But I think that that is only a piece of what's of concern to all of us. What we're concerned with is that vis-a-vis the entire settlement.
Exactly.
So if you're going to move forward with an approach of transparency, which I think you should, then the conflict of interest guidance that you had from counsel would be gratefully received by all of us within the context of the ability to review the entire contract before it's reviewed.
I have I guess a question / comment. If you do waive the attorney-client privilege relative to the opinions that you've received, the 3 memos you've alluded to, and any one of the 3 memos in whole or in part mentions the resolution on which you're voting tonight, and any link that it may have with any potential settlement of the CMSA lawsuit, our Ross Valley Sanitary District versus CMSA, I question whether or not there is any right for you to assert a limited privilege that applies only to the resolution by waiving the attorney-client privilege relative to the memos that you've received. If those memos in any way discuss how adoption of the resolution may affect the lawsuit, then I believe you may be waiving any attorney-client privilege you have relative to the lawsuit as well.
Andrea, was that comment from a member of the public?
Yes.
Okay, so first of all, let me remind the board that you're still in board discussions and you haven't opened this up item up to comment from the public yet, just as a point of order. Second, I view these legal questions as separate ones, and I do not view the release and waiver of attorney-client privilege for the very limited issue on tonight's resolution as a waiver of any other document but that. Just for what it's worth.
That's one opinion.
So our attorney.
It is our attorney. So.
Right.
Yes.
Yeah. I heard there were 3 memos. I also thought I heard 2 directors say they had not read all the memos. I would like to know whether all the directors have read all 3 memos. I think that is pertinent to this meeting and any actions you take whatsoever. How about it, Andrea?
Andrea, she's asking if all the board members have read the memos or not, what are the consequences? Is that,
If the board members have not read all 3 memos regarding the conflict interest, I would like to know that is in fact the case. That was my question.
That is, I'm sorry, but that is a matter for the board and its attorney. I don't think that that's appropriate for the board to respond to that comment.
You would say it's inappropriate for them to tell the public whether they have read the memos regarding the conflict of interest. Is that what you're saying?
Can she hear us?
I don't know.
I'm saying that it's not appropriate for the board, it's not necessary for the board to respond to that question.
Necessary.
Their decision.
I don't think it's germane. Any other comments from the
It's very germane.
public?
Yeah,
In other words, it has the board read all the minutes, but you know, all the detailed documents.
Has the
Yes,
board
sir.
read the entire law?
to address this,
Pardon me?
I certainly accept that the board has time requirements outside of being right here. And I certainly know that ever since the 1980s, all boards have been burdened with more and more reading material to come up with an educated and balanced opinion. But I do think it's very prudent if somebody wants to make a vote on behalf of whoever they represent to be as well informed as reasonably possible. And if there is documentation before you, you can say, we're sorry. And I accept that, you know what, hey, I had to go grab my dog, he's swimming in the bay or something, but I need an additional half hour or 45 minutes to read all documents so I can represent the people that voted for me to make an educated opinion and vote on our behalf.
Thank you.
Aren't we really asking to release it to you? I mean, we've been talking about transparency since I got here. And here we have some limited, at this time, documents relevant to the one, number 4 that we're going to discuss tonight that might clear up some issues. I mean, it's not just if we read it. We're saying, let you read it. I mean,
And release the entire document.
that's not what we're being...
No, because that's what is important, for us to know the entire document, the entire, what was said about his potential conflict of interest. And you are only picking out one part of it to say that he can vote on the resolution this evening, versus we don't know the rest of it. So, you know, what is that? That casts a shadow of doubt if you don't want to release the whole document.
Andrea? Oh, I'm sorry.
I mean, really, that seems to me it would make more sense to release the entire
Andrea,
document.
can we release all of the information tonight? Can we, don't we need to have that as an agenda item?
You're going to breach the
Is that a question, please?
Yes. I'm asking, don't we have to?
I mean, I think there, like I said before, I think there's a minimal but existing connection between tonight's resolution and resolution of the litigation. Frankly, my view on all of this is a matter between the board and its attorney. And frankly, my comfort in allowing the board to move forward on voting on a resolution tonight, and I'm not sure that it will really, it may help to release some of this information or all of the information, and that's the board's decision to do so. In the end, it's my job from an agency perspective to feel comfortable with allowing the board to move forward on this vote this evening, and I'm comfortable with it, regardless of whether you released any of the information that you've gotten that's privileged and confidential from your outside counsel.
Did she answer your question? There are the three memos, and it sounds as if one is a summation of two, in effect.
Just one.
So if that is the case, maybe you should ask her instead. It sounds as if you want to release the memo that's a summation of the other two. Ask her if it's permissible.
I would personally like to release all three.
Well, ask her. You can do whatever you want, regardless of her advice. If you choose to do so, you do so. But ask her if you may do so,
Yeah.
and then I recommend.
Let's see if you can.
Let me just see if I can clarify a little bit. First of all, if it seems last minute, it's because we literally just got these, so it is last minute. There are, as I think has already been said, there are three documents. They address the range of topics, and what I have understood legal counsel's guidance to the board to be is that one of those documents has a very narrow focus on the topic that's before you this evening, and that it addresses the conflict of interest issue for the topic that's in front of you this evening on the agenda. If at a future time you would like to consider the same question for the remainder of the documents that you have received, you may do so. But I think what I'm understanding is you have one purposely narrowly crafted document that you can release that is related to the item this evening because it's properly agendized. It doesn't preclude you in the future from making future decisions about the remainder of this work. And I'll kind of stop there because this is a legal discussion.
Let's bring it back to the board.
That's not what she said. She said there was a link between tonight's agenda item and the litigation, however tenuous. She said it. I heard it.
Yeah.
Did you all hear it?
Yeah.
Okay.
Okay, now we're going to bring it back to the board unless somebody else has a comment right now.
Well, you said you were in favor of releasing all the documents. That's what you said. You just
Let
said,
me-
why don't you just
okay.
release it all?
And release all the information about the settlement too.
It sounds like
Be
there's.
transparent 100%.
May I make a comment, and you may tell me if I'm right or wrong, but it sounds as if there's confusion reigning because the three memos address what the public perceives to be the issue of the conflict of interest, and there are two prongs to it. The conflict relates to the lawsuit, and the conflict relates to the resolution before you here tonight. And it sounds as if what information you want to release here tonight relates only to the conflict as it relates to the resolution. Only the resolution.
No, I believe it's not that. I believe that there's one 2 or 3 page memo that relates to the bond issue tonight, item 4. And there's 2 others that are very general. They don't relate to the settlement. It's just general conflict of interest. Do I have one or not? And so that's my understanding of when I read it. It's not, do I have a conflict of interest? Just for this or for that. It's in general, do I have a conflict of interest or not? And as I understand it too, since we didn't agendize the conflict of interest, we got it this morning. I don't think we can vote on it as a board. And so, but because of this, there's a specific relationship. She's saying, okay, for this one item, you can release a limited piece of information. That's it. Am I not right on that?
So, but then the question is, if you release that information, does it blow the lid on all the other information so that you have to release that too?
I ask this question. We have a board meeting, I believe, on the 18th. And on the 18th, if we make it on the agenda to do so, then we can do whatever I think we want to do
Right.
on anything.
Right, because then that,
Hang on, let me please finish. Okay. This morning, and I've been talking to council during the course of this day, trying to find out, because I asked the same thing as you, what legally, and I know that's, it's a hard term, but what legally,
I'm a lawyer.
I know, no.
Not so difficult.
But what legally can we do today without breaking any rules? And what I was informed is that because the resolution is on the agenda and this one document very narrowly applies to that resolution, that if we vote on it as a board, I can't do it. Lord knows I was asked to today to release it. I can't. But as a board, if we choose to and we get a majority, that we can release this very narrow document. And I'm going to tell you that I'm going to ask that for the 18th agenda, which is what, a week away, that we try and see if we can get on the agenda what all we can release, which may include some of the other documents that you're looking at. We just can't.
The board has a responsibility to the public to release documents as soon as they get them. I mean, this is an important issue that the public has questions about, and yet you want to hold it for weeks before any information is released. This is, if you got it this morning, it should be released immediately. Give it to your PR person and write the press.
I understand
Ask the lawyer.
Well, I understand the dilemma because you're talking about two separate issues. One, what you're permitted to do pursuant to the Brown Act, and you may only act on items that are on the agenda. And the item on the agenda tonight, which we're now discussing, relates to the bond issue, item number 4. And so you only may discuss matters that relate to that issue because the other issue that we're speaking of is yet to be on the agenda. So those are two separate matters.
Right.
So so
let's do this. I'd like to bring this back to the board. I think we've heard pretty much. So, what's the pleasure of the board?
I have a question for Andrea. Andrea, are you there?
Listen, Mr. Washington, can I make a recommendation here?
Yes.
I strongly recommend that somebody put a motion on the table and the board vote on it, and that the public comment be stayed until there's an opportunity to do so before the board votes on the motion. I think that this is not an efficient use of the board or the public's time.
Well, that's what we're
I
trying to
still
do.
have one question for you, Andrea.
Without the input from the public, and then you vote.
Okay, Andrea,
So-
I need to ask one question, please. I've been trying to ask a question for that. Andrea, for public records requests, does the public have the right to these documents? I've seen it on the board here where the newspaper asked for a public records request, and when you know what I'm talking about, for me, when those records were released to the newspaper.
After review by council, that there was not an argument that they were protected attorney-client privilege.
Andrea?
Okay,
Yeah.
so I guess
Do you
not.
want me to respond to that since I have the background on that?
Oh, right. Jolie Houston.
On the public
Two
records
attorneys?
request about the correspondence? No,
The public records
that
request.
Director Mason was talking about.
Yeah, can you?
Go ahead.
I don't remember.
Yeah, Jolie.
Yeah, well, if I don't just in case there's an issue that comes up that we have to talk about the bonds or if Andrea has a conflict, but I believe what Director Mason was talking about is a public records request for a document that was maintained as attorney-client, but ultimately was released because it dealt with it dealt with a high-level board member and a high-level director, and the attorney for the paper wanted release of it for arguing that the public's right to know outweighed
Okay,
Thank you.
thanks, Julie. Okay, what's the pleasure of the board?
I would like to move that on the very narrow issue that we have before us tonight, before we can really discuss it, in the interest of transparency, which you've all been asking for, I wish we could do everything, but I hope that I move that we release that one very narrow document to you right now. We got nothing to hide. We can't legally do the other, Nancy. Can't do it. I don't want to get in trouble.
I mean, I think
No, it's okay.
it harms Mr. Gaffney's
The board knows.
reputation to cast aspersions.
I would like, and then and you will see at the end of this meeting, I'm going to ask on the agenda, not weeks or months away, 18th, that we have an agenda item, and we do the rest of it as an agenda item where we can legally do what you're asking.
It's an informational, it's not an
Please,
action
no,
item.
it's not open to the
informational,
public
it should be
anymore.
I move that.
We have a
I move that
motion.
we-
We have a second.
I'll second it to take it to a vote.
Okay.
Any further discussion by the board?
Yes, just if I may comment on the motion itself. So there are three distinct issues swirling around here tonight. There's the resolution regarding the refinance, and that's item number 4. There's the settlement issue of Ross Valley Sanitary District versus CMSA, County of Marin, and California Department of Corrections and Rehabilitation. And there's the Brown Act that covers board actions. And the Brown Act allows the board to act on a matter that's either posted on the agenda or there's been a motion that says that, in fact, the item came too late to be posted on the agenda. It's an emergency item, and I think it takes a 4/5 vote to add it to the agenda. In order to vote on, if we were going to vote on releasing all 3 documents tonight. So the board is caught between a couple of conflicting laws, and if we look at a strict interpretation of the Brown Act, the only one that can be released tonight, and that's kind of a gray area according to our new counsel, but it does relate to the issue of the resolution for the refinance. So I'm going to vote for that motion tonight, and I'll support a motion to add the other 2 legal opinions to the next agenda.
Okay, any other board comments? Okay, we have a motion and a second.
So do we need to?
This does not need to be a roll call unless you prefer that.
And I'd like to hear the motion again, just so it's clear, please.
I move that on the very narrow agenda item tonight, that in order to make it clear what has been discussed privately, that we release the narrow version of the document that pertains only to this tonight, and that's the only part of this, and you've heard what I want to say about this. So I move that we release this very narrow document that we received and release it to the public.
You mean page 3 of it? The last page? There's 3 pages.
The full document.
It's 2 pages.
2?
It's actually 1, 2, it's actually
There's 3 attached.
3 pages.
It's 3 pages.
Okay.
It's titled, if I may.
And then we make copies available to you right now.
Okay,
So it's clear
yeah,
what the
read
motion
it.
is. It's titled Financial Conflict of Interest Concerning Board Member Gaffney, Resolution Concerning Issuance of CMSA Refunding Revenue Bonds. That is what's going to be released by this motion.
So, any other board member comments? We've had comments from the public.
When you vote on this,
Right now.
is it, no, I explained that, but I'm also hoping to hear, so I just want to make sure we get to hear afterwards, the actual financial implications of the bond going forward, so that's still separate.
It's still separate.
We haven't done anything.
We haven't gotten to that.
Just in terms of squirrel in this.
Okay, it's not a roll call.
This particular vote does not need to be a roll call unless you so desire.
I desire.
A roll call, okay.
Director Gorski?
Aye.
Director Silla?
Aye.
Director Meggs?
Aye.
Director Eger?
Aye.
Director Gaffney?
All right.
Can we make copies of that? Sure.
Okay, now, back to agenda item 4. Adopt resolution 154989 regarding the issuance of Central Marin Sanitation Agency refunding revenue bond series 2015. And from what I understand, just the savings are in the order, the total savings are in the order of $650,000 plus a year
To the JPA.
for the total JPA for 15 or so years? 17 years. And our share of that is about 40 to 45%.
Here's the exact numbers.
Our share is 44.5%, just about $300,000 a year for 17 years. Okay, so board member, initial comments?
Well, I've got some questions rather than comments.
Oh, that's okay, sure.
Yeah, but let's talk about this a little bit. So I've got tomorrow night's Central Marin Sanitation Agency packet. And tomorrow night, it is item number 9 that we'll be voting on, a resolution of Central Marin Sanitation Agency authorizing the issuance of revenue bonds and authorizing the execution and delivery of the second supplemental indenture, a notice of sale, and an official statement, and approving the appointment of trustee for the bonds. So I've gone through the packet, read the resolution, and the difference between what's going to be voted on tomorrow night and the resolution tonight that we're looking at Ross Valley Sanitary District is this section 5, what I call a poison pill. It talks about the effective date. So on tonight's resolution that we're looking at, section 5 says this resolution shall take effect from and after the date of its passage and adoption, provided that the effectiveness of the resolution shall be conditioned upon the approval of the district's board and CMSA's board of a settlement agreement between district and CMSA in the pending litigation in Superior Court County of Sonoma, case number SCB 252383, and entitled Sanitary District Number 1 of Marin County versus Central Marin Sanitation Agency et al. So the one that we're looking at, the resolution we're looking at, talks about an effective date and the settlement. It's conditioned on the settlement. So the question I have for our council, we have 2 of them on the line. If that section 5 were deleted from this resolution, or deleted, or if this section 5 was amended, and the amendment would be as such, back to the resolution, effective date, and it talks about shall be conditioned upon the approval. And the word either would be put in front of the approval. So it would be conditioned upon either the approval, and then as it's stated, on down to the end, et al., and then add the words, or if tried, a decision in Sonoma County Superior Court. So in effect, the resolution would say it's going to become effective through either a settlement or a decision coming out of the Sonoma County Superior Court, one or the other. So 2 questions. 1, if we drop section 5 totally, or number 2, if we amended it, as I mentioned. How would that affect the resolution, and how would that affect the authority of CMSA to issue bonds? That doesn't tie us down to either a settlement or a trial decision. Does that make sense?
Jolie, did you get that?
Director, you've got 2 questions, and I'm going to address the first one being, what if you remove section 5 in its entirety? Is that the accurate first question?
affect the sale and any future litigation determination?
So each response will address the effects of the litigation and the effects of the sale of the bar. Okay? So in response to the first question regarding removing Section 5, deleting it in its entirety, the effects of the litigation would be likely that the payment agreement becomes, and this is a bit of a problem to discuss this in open session, but in essence, you vote on the bond. You are advocating either settlement of the litigation or the dismissal of the litigation because of the payment agreement and the implication of the payment agreement on the principal issues that the district has in the litigation. So, in response to your first request, deleting that section would have the impact on litigation of an acknowledgement that the payment agreement is valid in the adverse interest to the district in litigation. And I think it would have no impact on voting up or down to the bond. On the second question, and very sure that I have adequately understood your question, you wanted to amend Section 5 so that it includes either approval or resolve through trial. Is that accurate, Director?
Yes.
I couldn't quite hear you. We heard either the approval,
Or resolved through trial.
or, is that what you said, or the results of the trial?
Resolved.
Resolved through trial.
Resolved through trial, okay. So that's the question. Can this Section 5 be amended to include basically those terms?
Okay. The problem I see with that on the litigation is, again, as a district, you're acknowledging the payment agreement, but at the same time, you're attempting to say, well, the payment agreement is valid as long as we don't have, if we have approval, but it's not valid until we go to trial. That's problematic.
No,
So I think that it would have the same impact on the litigation as I previously stated, because you've got this, you take this position where you want the bond to be issued with the understanding that there's a payment agreement exists. But at the same time, you don't want the payment agreement to be valid until you've litigated the trial. And I don't think that works in the litigation. And then secondly, as to the bond, from my understanding of talking with bond counsel, that will not work because of the training. The bond has to be done this month. The trial is not going to happen this month.
So let me,
And
okay.
this is second hand, but from what I am told, the bonds will not work if the projected settlement, or resolution, I should say, through litigation is up to a date unknown. So does that answer your two questions?
So on the issue of revenue to pay off the bonds, CMSA is going to get the revenue from San Quentin either way. They're going to get the revenue from San Quentin if they prevailed in litigation, and they're going to get the revenue from San Quentin if Ross Valley prevails, because we're going to pay them for treating the wastewater for San Quentin. Either way, they're going to get paid. So is there any way to couch the payment that they're going to receive, the revenue to pay off the bonds, in terms of either way, they're getting the revenue? Win or lose, they're getting that revenue, so that it wouldn't impact the verbiage in how the revenue pays for the bonds. Does that make sense?
Okay, I think your question that is there a way to structure the agreement conditioned on how CMSA collects money from the prisons, whether it's directly from St. Louis prison or through Ross Valley? Is that accurate?
Yes. Could it be slightly rewritten, the financials on it, so that it shows the revenue's coming in either way, and that would be acceptable to bond counsel?
There were discussions with bond counsel, and I'm not bond counsel, so I can't say whether something like that would work. But again, it's conditional in the sense of either the funds come from the prisons as they are now, for contract with CMSA, or at some point down the road, in the event of successful litigation. Again, that is
Okay, for 30 years, for 30 years, CMSA was paid for the treatment of San Quentin's wastewater by the Ross Valley Sanitary District. So the only thing that changed was 2 years ago, instead of Ross Valley paying CMSA for treating San Quentin sewage, wastewater, San Quentin paid CMSA directly. The dollars are consistent. They've been consistent for over 30 years. And they're not going to change now. They're still going to get the money. That's number one. Number two, it seems that if you're saying that this has to be done in 30 days, then perhaps Ross Valley would get a better settlement deal out of it. If it's imperative to be settled in 30 days, then we otherwise might get it.
Again, I think I understand, but the problem with the record is, it goes back to the payment agreement. Payment agreement, memorializes the CMSA and CDCR use of the pipe on station, and that the payment that the CMSA is now obtaining as revenue, whereas all other bonds or payment agreements, CMSA doesn't have that. It has a tax group through its members who pay CMSA. Now, you have a payment agreement that has been drafted by CMSA that shows it having revenue, which I don't know why, I was concerned that we're getting this, we're discussing settlement or and actually litigation issue in a public meeting, but you have potential issues with payment agreement, and I really can't discuss it any further than that. It's payment agreement amendment. So it's a payment agreement amendment.
You done
Yeah, you want
Christian, so if we vote with this last whereas about referencing CMSA, does that mean that we have voted for a settlement agreement as opposed to continuing the lawsuit?
The whereas as is now, is the bond, the approval by the district is conditional upon approval tonight or approval of the bond and a settlement with CMSA and DDCR.
Does that reference that we're dropping the lawsuit then? If we're just, so in other words, so does that mean by doing this resolution, we're moving towards a settlement rather than, and we're going to drop the lawsuit? Is that correct?
Okay, I think just so it's clear, you're asking if, and I apologize, this is not a whereas section, this is actually section 5. Section 5 is trigger. You're saying that the wording of the section 5 now is a vote that would be a vote to approve the bond and adopt some type of settlement between the district, CMSA, and San Quentin State Prison. That would be accurate. If you want, I can discuss the alternative to just dismissing the lawsuit.
So can we take out that section, and if we take out that section, that last section of the whereas, then that leaves it sort of wide open. We could continue the lawsuit, we could come up with a settlement, etc. Is that right? Do we have to have that in there? That's what I'm saying.
We could, but what, as I understand it, if we go forward with the bond refinance, which is what this is, we are putting ourselves in a worse position vis-a-vis our legal claims in the lawsuit. And so that's why the lawyers are uncomfortable with it. We're basically saying, because we want to refi the bond, we're going to give up this point of our lawsuit. And so the lawyers are saying, we don't want you to give up that point of your lawsuit. So let's put a clause in here that says, yeah, we'll go forward with the bonds if we settle, because we are disadvantaging ourselves in the lawsuit. So for those people who are interested in definitely refinancing the bonds and definitely pursuing active litigation, those things are in conflict
with this.
So my other question, Christian, then,
is that correct, Christian?
Okay. So what I'm trying to also get at then, we don't really know what the judge will say or not say. This is all projection and what you're thinking. Yeah, we might get dinged, but the lawsuit could go ahead and we could win, correct? They're not going to make the judgment totally on the fact that we decided to go ahead with the lawsuit.
Talking about the published section.
I know, but I'm trying to see.
It's an evidentiary issue. I would suffice to say that this would have an adverse evidentiary effect on us.
Okay, but it doesn't mean. Okay.
If it was approved as written?
It's not on the agenda.
The bond's on the agenda? What are you talking about? Okay, I think I...
But the bonds memorialize the payment amendment, right?
Yeah.
Christian, you keep saying that we have to settle.
Right.
Christian, you say that we have to settle in accordance with 5 with CMSA and the prison, and it doesn't say the prison, it says just CMSA. And as I understand it, we're settling, if we do settle, it's going to be 3 separate agreements. And so I don't think 5 requires us to have an agreement with San Quentin Prison, at least not the way it looks like it's written to me. And then the other point that I wanted to make was that we requested you, Christian, to come up with language that, this is a lot more drastic than what I thought we were requesting. We were suggesting that you add some language that does our best to cover this, and not go to to link them completely together.
Right. Is there any way to say we do not intend for the refinancing of the bond to be an admission against?
Yeah, why don't we just say something like that?
Or would that be?
Because the problem is you need to, and again, I discussed this with both sessions.
Right.
You need to get everyone's agreement that a stipulation that it doesn't mean something.
Right.
And I question whether a court would actually accept it.
Right.
And just to clarify, Tom, for the record, Section 5 does include settlement agreement by the district on the CNSA and San Quentin State Prison. That's the last version of the resolution we have.
No, that's not what we have.
Oh, but you're not,
It's all.
it says at all. At
At
all.
all.
At all.
Did you hear that, Jolie?
Section,
It says at all in our version.
Well,
That includes everybody.
that's just the name of the litigation.
Oh, you're right.
Section 5,
Good. We have all the lawyers in there.
Section 5, go on.
yes. Approval of a settlement agreement by the district, CNSA and San Quentin Prison in the matter number CID 120283.
No, that's not what we have.
That's the agreement passed in bond council.
Okay. Well, they caught it, and it's not in ours.
It's not
So if we just deleted Section 5 altogether, because you're saying Section 5 has no impact on the bonds and may preserve an argument, and actually does, as Pam indicated. I mean, it assumes settlement. But since I don't think we have a consensus on this board of which direction we want to go, if we deleted it altogether, we understand that it may disadvantage us in the lawsuit, but it leaves open both opportunities. If we adopt it with Section 5 as written, we are moving down a path towards settlement and not leaving open the possibility of litigation.
Or not refundable.
Right, presuming we want the bonds to go forward. Right?
If you were to strike Section 5, you could strike Section 5. Or any language about settlement. Again, but you are correct in the sense that you are likely putting the district in a disadvantage, an evidentiary disadvantage, significantly disadvantaged position if you were to do that. But yes, you can. I mean, I think it's a big possibility, and in fact, there's been some debate on that. We'll strike Section 5 altogether, and just the district be prepared that it might have to dismiss the lawsuit.
Okay, so Christian, we've been working on this now for a couple of weeks. And so in the 2 weeks, this is the best you guys could come up with as far as protecting the rights and financial responsibilities of Ross Valley Sanitary District. And also CMSA. I mean, I would have hoped that we would have had something much better than this that would have protected everyone and allowed, if need be, the lawsuit to go forward, if need be.
Well,
I mean, I don't understand what this is the.
because we would need to get the other parties to say, yes, we agree not to use that point in our evidence jury.
Well, they might do that.
I don't think they would. That would be like litigating the case before we got to the court.
Absolutely not. What it would be saying is we're going to keep an open mind on litigation. That's what it says.
I think it would be unenforceable.
Can I make just a comment?
Well, another problem is we should have had these attorneys here tonight. We've got 3 attorneys on the phone, or 4 attorneys on the phone, and it's difficult for us to hear everything.
It is. They just find out who's talking.
Can I just make a statement? Because I get a lot of letters from all of you, and thank you for participating. That's the reason I'm here, is because I wanted to participate. a lot of talk has been, don't give away the assets. Everybody talks about that. And I'm just doing a little math here. If we don't sign this bond agreement and get it done, direct to us today, a direct loss today, $5,068,550 to us. But it doesn't stop there. San Rafael, the other party in here, $5,193,840. We have to take care of them too. I'm sorry, I didn't. No, we don't.
Director Bush, you guys just a point where
Yeah.
you guys have a discussion at the board right now.
Yeah.
So if
Okay.
you direct your comments to the board,
Thank
please.
you. And Corte Madera, direct savings $1,116,220 over the course of 17 years. But that's a direct asset. The direct asset that we're talking about, that we may own, we may not own, it is a pump station, which I think Director Egger valued at $1.5 million in his recent little article in the paper, and I believe it was $2.5 million for the force main. And even so, if you take those and then add in what we're a nonprofit organization, so we add a little capital improvement, we do a little admin, it's still, if we don't do this, this is a guaranteed today, on top of which we have, if we continue with the lawsuit, which this is not about the lawsuit tonight, but there's a financial thing there. If I'm looking strictly for the financial interest of the constituency, I'm looking at, we're talking about a force main which is old, which is probably in need of some maintenance, and God forbid that thing blows. We're 15 feet from the bay, and we're under still a cease and desist order. Anyway,
There's too many unknowns. You don't have good legal representation.
Wait a second.
It's poorly written.
It's at the board.
You're not transparent, and you have a conflict of interest. So don't vote on it, okay? It's a no, 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 no. Okay?
You don't even have the
I
document.
have a question for Jason. What is the timing of the bond sale? What is the sale date scheduled?
Well, in the schedule that we brought to the board back in November, when we got authorization to proceed with the refinancing process, it showed the agency closing the bond deal at the end of this month. So we've been tracking on all the different tasks and activities in that schedule in accordance with the schedule. So that's why we have the CMSA resolution tomorrow night. We're hopeful that your board approves the resolution tonight, and that we could, send the notice of sale out. We could have a competitive bid process.
When is the competitive bid? That's the closing doesn't matter. You lock in the bids at the sale date.
I don't have the schedule. It's going to be probably starting, in a week and a half.
A week and a half.
It's the 18th.
But it's tied to all the agencies approving their disclosure documents and to approve it. So.
Well, I'm kind of the opinion that we should have a better Section 5 than we got here. I think we ought to write as good a cover your backside as we can and live with it. That's my opinion.
If we cancel number 5, aren't we in effect doing that?
If we cancel it, we haven't done anything towards covering ourselves. If we just cancel it, we, in effect, de facto approve the payment agreement. And we don't say anything about it. That's what I understand. And I would like us to make some attempt to try and cover the payment agreement somehow, as best we can. We're going to go to the public in a second.
So, may I speak? I would agree with you. I'm really sorry our attorneys didn't come up with something better with 2 weeks to work on this. So, if that much money is at stake here, $10 million, it's incumbent upon everyone to write up a resolution that allows the refinance to go forward and not adversely impact the outcome of the litigation. I mean, we should be able to do both. It's all laid on Ross Valley. If you don't do this, this, and this, we're going to lose all the money. Well, wait a minute. We're all in this together, and I see no reason why we can't write a new section 5 that's acceptable to Central Marin, acceptable to Bond Council, acceptable to Santa Fe. Maybe we can get this done if we have a little bit more time. When do we come back again? The 18th?
That's when they're doing their, it's on their, I have it here, tentative sale on the 18th.
Well, they can postpone.
Okay,
Yeah,
well,
I
it could do the
this
19th.
this evening with 2 words.
Pardon me?
This evening with 2 words.
Sorry, we have a lawyer.
Well, let's ask Jason. Jason, we're here, we want to sell the lawn. We want to refund. Some of us don't want to give up everything in order to get the refund. Do you think it's possible that we could rewrite our number 5? You've seen it. Can we rewrite number 5 acceptable to the Bond Council, acceptable to CMSA, acceptable to Santa Fe? That says, yes, go forward, we're going forward, we're selling the bonds, and we're not going to resolve the litigation at this time.
Okay. I got a point. Even if we just get CMSA to approve, we approve the same thing CMSA approves. Doesn't that go a long way to help us? I think it does. In other words, we figure out some different language here. And CMSA agrees that we're not going to, you said they might not, but I think it's too big a deal here to pass up.
I don't know.
Yeah, the only answer I have is that hopefully the CMSA board approves their resolution to authorize a variety of activities, and then we can't issue notice of sale until Ross Valley approves your document. So the board needs to be comfortable with whatever language you guys need in your resolution, which approves your disclosure documents.
And you could have a special meeting of CMSA to approve the same thing.
We wouldn't approve your district's disclosure documents.
No, but you would approve our condition. And if we could write
your condition is your condition. Your condition
we would make it a mutual condition.
It wouldn't, the process of these resolutions are operating in a way that aren't necessarily binding the parties to anything besides really standard ideas that we need to go forward with the bonding, I think. So if we threw something in like, this resolution requires that the other parties to this litigation agree that they won't use the fact that we adopted this resolution against us in a court of law. I mean, if they agreed to that, the attorneys are saying it might not be enforceable anyway. It's a fact out there. So,
May not, but probably better than this,
But I think it slows up the process, and I don't think it does it to any effect. But I don't know, Christian?
Yes?
Sorry, did you hear what I said? Or anyway, I'm sorry.
Yes, I did. And you've addressed it perfectly. That's the problem. And you make an assumption that the county will agree with it, and the state will agree with it.
No.
And the state will agree with it, including general services.
Right. Any attorney could use it.
I don't think they will, and I think that, as you said,
There's $10 million at stake here. Why wouldn't they?
you're asking the court to, on the one hand, ignore the payment agreement amendment for your benefit. But at the same time, you're asking to get the benefit of the payment agreement amendment that you wouldn't have otherwise unless you show it to work.
Any attorney could use this idea that we have agreed to something. Pardon me, just that it wouldn't have to be CMSA's attorney. It could be some other part. It could be the CDCR's attorney. It could be the county's attorney. People who aren't parties to the bond reissue. So
Could you said use it
in the litigation,
and
yeah.
use it against
Yeah,
us?
I mean, we're trying to have our cake and eat it too. And so I think we need to make a decision of whether we want the bond refi, $5 million, or whether we want to pursue the litigation.
Nonsense.
It's that simple to me. I think people who want to do both, we are admitting that we play in the world post Ross Valley Sanitary District, being the only provider of sewer services to San Quentin. And that in my opinion, is in the ratepayers' best interest at this point. For that $5 million and for the cost of legal fees. And when we have 3 attorneys show up to the meeting in person, people say, why do we have so many attorneys show up to the meeting? So we're trying to do
They're
our
going
best.
to talk to the ratepayers, they don't have a clue what you're up to. So,
I want to add, though, that this is an attorney's opinion. And I'm for the refi. We actually, Frank and I have already given our vote at the CMSA commission meeting to go ahead. Little did we know that this little added section would be here today before us. And attorneys from our district, hired by our district, have given us misinformation. There is some kind of issue going on with one attorney saying one thing and one attorney saying another. So we were told, go ahead and vote on the bonds. Then we were told we shouldn't have voted on the bonds for CMSA. I'm trying to be a good neighbor and do what is best for the ratepayer. And I can't say, Christian, that this has been an easy road for a board member to get incongruent information on this big of an issue affecting this many ratepayers, etc. And I, this is not helpful, this section 5. It's kind of like, okay, well, I think the judge is going to say, it's going to put it against you, so we'll just give it up and create the settlement, and that's it. And so I don't think due diligence has been totally done here. So I want to vote for the bond, that if I have to vote to say I'm going to be cornered to do something else about a lawsuit, that a Sonoma judge has said we have a right to vote. It was not dropped on an appeal by CMSA to drop it. Do you see the quandary that we're in? So I don't know what I'm going to do here, but it's not in the best interest of the public. It's not. Totally not. And as far as attorney fees, we've done a lot of discovery and preliminary work. I don't think it's going to be that much more attorney fees, so I'm done.
The public.
We have no knowledge of the vote at CMSA, so there's no misinformation. We could not advise you on that because we weren't aware of it. So I don't know why.
I was advised on it.
It's okay. Let's move on. We're going to move to the public now. We're going to move to the public. Yes, sir.
Okay.
We're moving to the public now.
Okay. If I may.
Yes, sir.
Okay, at the risk of embarrassing myself, a couple suggestions, some information, and then some questions. Okay, so the first one, to your section number 5, I believe that you could resolve this in settlement within this scope. It's probably a term of art. You just change it to a resolution and or agreement. Okay, resolution can be a trial or not. A settlement can still be a resolution or agreement.
The trial doesn't work because a trial isn't going to happen for a year.
No, but I'm saying is take that word out. Just say a resolution, like between the parties, and or agreement. Take the word settlement out.
So you're saying a negotiated settlement?
I'm not using the word settlement intentionally.
We still have to come up with an agreement.
Well, no, you can still come up with an agreement. And I believe that if the bonding companies are involved in this decision, it might be because they don't want to see open litigation that will affect your credit ratings and such. So it's an unknown quantity.
Well, it's been written up at the time, but anyway, I don't know. Thank you.
So
That's your next idea.
But my question too, since you're voting on the bond, what I would like to know is what the duration of the bond is, and if in fact we're extending the original financing period.
We're not. It's a 17 years on the existing bond, and the new refunding bond will be for 17 years.
So in other words, all we're doing is only refinancing refinancing the existing length of the pre-existing.
We're not extending the length of the mortgage. You have the same term.
Okay.
Yeah. It runs to 20.
So the savings are real savings. They're every single year, bang, bang, bang. Instead of paying, $650,000 more, we're paying $650,000 less for the exact same plan.
You know, something else too, and I, again, I apologize if I embarrassed myself, but I believe that if you enter a contract with CMSA, and it's the same contract, that it has to be mutual for both parties, what that language is, and I believe that's covered in CCP 1714.
Well, that's kind of what I was thinking, but I didn't know what it was. Yes.
Okay, two things. Number one, it seems to me that what I'm hearing here in the discussion among the members of the board who don't agree on everything, but it seems like you agree on one thing, which is that you don't have all of the information that you, in the ideal world, like to have. And that some of the information has come to you either a little bit by surprise, contrary to what you expected in terms of language. Language isn't exactly what you're looking at in front of you, or it came in so belatedly that you really didn't have time to properly engage in a full understanding of what you might be voting on and how your various council feel about it. And they're not all in agreement either. So it seems to me that the logical thing to do here is to take a deep breath and say, another week, another 2 weeks, we've got $10 million at stake here and 17 years hanging over us. Constituents who want to hold us to a certain standard of transparency, let's take the extra 2 weeks. And the only argument that I can hear against that is that somebody at some point, going back a number of months ago, pinned a schedule for the bond. And having worked on Wall Street for 20 years, it happens all the time that the schedule slips. In fact, they usually slip. So take the time and do the right thing.
The only downside is that we've got really good interest rates right now, and there's been some pressure on them. We've heard a few things, so yeah, we can postpone it, but there's a risk.
But they go both ways. In 2 weeks, they could go up, they could go down. You don't know.
Okay, but would you like to comment? Yes.
I think you've been ill-served by this combination of counsel, and I'm always somewhat alarmed when I completely agree with Frank, but I think he was onto something, that this should not depend on settlement or resolution of the lawsuit, because CMSA is going to get paid either by San Quentin or by Ross Valley Sanitary District, no matter what happens in the future with respect to the lawsuit. And there ought to be a way to resolve this so that that reality is recognized rather than the contingencies of litigation. And even going the way Mary Silla was suggesting about having the attorneys say they're not going to use it in a certain way, that's not a good way to go either. But there's got to be a way to do this, and they're not going to tell you on the phone here with all of us listening. You can work this out in a reasonably short period of time, I think. We could hold our feet to the fire, and then come back to us when you've got something that meets Director Eggers' objectives here. That's what I would like to see.
Yeah, I kind of agree. You agree with that. Any more comments from the public? You know, I tell you the truth, I've really enjoyed the fact that we've had people here listening to us. It sounds like we disagree all the time. We basically don't. We agree. But anyway, no more of the talk.
Go ahead, Nancy.
Okay, I mean, I have some questions, and it may not be fair to ask them, and I want to thank Wendy for getting me the paperwork on Friday that was in the process of kind of being finalized. So anyhow, this is such a very complicated situation, and yeah, I think that it would be a good idea to hold off and get some more information out. But I just don't understand the contract with San Quentin was left out of the bond completely. You know, I mean, that is substantial income that's coming to the district, And the fact that the contract was done and all the lawsuit, I mean, the public really needs some transparency to know what's going on, to understand this. I mean, there's revenue that we should have earned that we've been basically doing for free, it's this laundering of money through the district. It's very complicated and it's very confusing to have the assets of our public agency that we vote for board members to sit on and take care of. The public doesn't know anything about this, and to find out that, this contract has been done with the Department of Corrections and how come it's being continuing on and being renegotiated and whatever, it just doesn't make any sense to me. And also, I'm just wondering about the district's liability. It doesn't seem that there is anything that's protecting us and our assets when this continued fraudulent contract is going on. But once again, we don't know even about the contract. So I don't understand why this can't be all made public and the public informed about this stuff. We're informed that, the pipes are falling apart and that you need more money and you're going to raise the rates and all this stuff. So, and suddenly you're going to renegotiate something when, in fact, we may have even more lawsuits down. The district, like I've said before, has a very poor track record. We've got the former director in jail. We've got huge real estate losses. It's almost like a bad novel. I remember the first time I even saw the district was that all the board of directors had been going to Palm Springs on huge junkets, and wasn't this funny? But ultimately, if the plan is that there is going to be no more district elected representatives, because it seems to me that that's the way things are going, that you want to have a JPA and you don't want the public involved in finding out about any of this stuff, which will then keep it even more underground. Maybe that's the ultimate plan. Just consolidate with a JPA where you have the public can just stay at home and watch TV, because that's kind of what they prefer. So anyhow, if I go to the meeting tomorrow as a public, I have you guys as representatives for me as Ross Valley, but I have no influence over any of those. Those are not elected officials. They're appointed by their various boards. So anyhow, if you guys go away, then the public in the Ross Valley loses their elected representatives. And I think that would be sad. So anyhow, I think it would be a good idea to wait and recraft this and let the public know about what this lawsuit is going on. Thank you.
I think I heard the attorney say that it sounds to me as if you have one written drafted resolution before you, but the attorney had a different version of it. So if that's the case, I think you better make sure you're all on the same page and have the same resolution, because you want to make sure you're voting on something that has been approved by council. So if you don't have that in front of you, wait.
What is the elevation of the pump? What is the elevation of the pump plant relative to when we talk about
San Quentin's pump station?
Yes, please.
20 feet.
I have since been given a copy that you have, which is different from one that I had. There's no material to it.
Yeah, it just puts the case name in.
Yeah, there's no material to it.
And it doesn't specifically refer to having a settlement agreement with San Quentin. It does not.
I understand this.
Okay.
Yeah, it wasn't the one that we had done from on council.
Okay, thanks. What was your point? What's the elevation of the pump station?
No, of the processing plant, right?
Oh, excuse me,
No,
I guess the pump as well as processing, because I did participate in some discussions with San Rafael when they raised one of their manholes in anticipation of raising their pump station on San Pedro Road. And so there are discussions about this, so I was curious if you guys can.
Jason might.
Yeah, I know the elevation difference between high tide in the bay and the San Quentin pump station.
But you know how many million gallons you can't treat when the tide's in. It's like another 10 million gallons you can't put out in the deep water when the tide's in, right?
We resolved that.
You did resolve
With
that.
a new pumping facility, yeah.
And as the tide goes up, as the
Okay.
tide level rises?
Let's bring it back to the
Yeah.
board now. What's the pleasure of the board? I think, I guess we all want to refund the bond issue.
I am very concerned. I mean, I hear everybody's concern about we're moving too fast. Frankly, we've been talking about this for months, and every year, I'm going to collect my thoughts.
I mean, after Laura spoke, I thought, I don't want anybody to perceive that I think I'm just explaining my understanding of the legal perspective on this, that means that I don't think there's in some language we could put in here that would do our best. I mean, I thought for a moment about whether it could be a whereas, because frankly, that would be the force of it, saying, whereas we have this ongoing dispute about the payment streams that, what the lawyers, in effect, are saying to us is you are going to memorialize that too. You're going to say, we're going to take some money off of the fact that this payment scheme exists. But I think that a good lawyer for us could argue in court, of course, these are entities that have to work together in the common interest, and they can have a dispute, and it could be litigated. So I'm not saying, we have to fish or cut bait at this moment. This board certainly doesn't have a history of fishing or cutting bait at all before necessary. So perhaps there is language we could put in. I think we all ought to, if we decide to do that, we all ought to understand that it's not airtight and that it's not going to make our lawyers comfortable. And if it doesn't work, we're not going to be able to sue them for malpractice because they let us pass this bond resolution tonight. We got to bear in mind what we may be doing to ourselves in terms of giving something away in the litigation. But I think, it's been a great deliberative process, and I wouldn't be opposed to trying to get more language. But as long as we all recognize that it's not going to be airtight, it's not going to be something that's slam dunk when we get to litigation, this isn't going to come back and bite us.
Taylor, do you have any comments?
Well, I brought it up earlier because that was sort of the thing that I saw crystal clear was it's kind of putting us to a place of not working with an agency again. It's like this weird karma that keeps showing up, and I thought there's got to be another way. And obviously we have attorneys, and I think it's like anything. They do the best they can, but I still feel that it's not black or white. And it would actually, in some ways, we are helping CMSA, yes, but we're also taking care of our agency too.
Yes.
And we're not caving in, and we're not going to say, okay, well, and here's the settlement because we want you to refi. I feel that we need to step back, take our position, look at it more carefully and more distinctly, and come up with a more unified vote.
For myself, yes, it's been talked about for months in closed session.
Yeah.
The public really doesn't know what we've been doing for months because it's been in closed session. And they're public's playing catch up with what we've been doing for months. I'd like to see us continue this until March 18th, and I have Mary and I sit down with our counsel to come up with language that protects the ability and resources of the Sanitary District and allows the bond sale to go through.
Protect as well as possible.
Protect as well as possible.
Want to make a motion?
You want to move? I'll move it. I would so move that we would continue item 4 until March 18th. That board directors Scylla and Ager will sit down with council. Whatever ones they think.
Yeah, which one's appropriate?
It may be Tom, it may be it may be Christian, and it may be Andrea. What?
Cut off? No, Andrea hung. She probably lost. Okay.
No, she's gone? Okay. Okay. But that's okay. We make the contact.
Okay.
So the motion is, and to bring it back on the 18th, at the public meeting at the Central Marin Police Authority headquarters.
And that will be an ad hoc committee.
Is there a second?
Well, we're basically that.
I'll second.
I would like to ask a question of Jason. One thing I'm very cognizant of is the constituents' assets. What you've all been writing to me about, be very, very, very careful. And I'm looking at a solid number here. Whatever the number was, millions of dollars over the next 17 years. And I'm not understanding, I mean, that's our asset. It's a bigger asset, as near as I can tell. Maybe we get the pipe, maybe we don't get the pipe. These are millions of dollars that are in our pocket today. I would still like to see us negotiate, figure out. I mean, I'm hearing about, lost revenue. As I understand it, that we are not flexible. We don't make a profit off of San Quentin. It's not revenue that we're losing. It's revenue that we're not responsible for. If CMSA is charging us for the effluent, and we are then taking that and adding in a little bit of numbers, we're adding in our costs. We're not making a profit. And so I'm not sure if we win and we get the pipes, we don't make a profit. If we win and we lose, we don't get the pipes. We're the same that we are right now. If we win, I understand. Everybody I talk to says that the state will appeal the case, and we're still in it. So if we win, we lose. If we lose, we lose. And you know what that's.
I agree with rewriting this, because I'm afraid that it would take us too long to reach an agreement, a settlement agreement, and that would delay the bond issue more. And so, I'm essentially in favor of the motion in a second. Any more discussion?
I just want to ask, I guess, staff, if we passed a resolution, of this type with another paragraph that we work out on the 18th, what is the impact on CMSA's schedule? Their schedule gets pushed back somewhat?
About a week, maybe?
A lot? Does it still need to come back to a full CMSA board meeting to be approved or not?
They've already approved. We voted. Panel actually voted for
Okay.
for the
Okay, so
resolution
no, there
last
doesn't
time.
need to be
It's
a-
on again. Is it the same? Excuse me. Is this the same resolution tomorrow night that we voted to approve last time, Jason? Or is it different?
Well, you guys, the CMSA boards approved a few separate, events. One was to begin the process, one was to bond council agreements, one was to select that savings scenario for the structure of the bond issuance. Now what's before the CMSA board tomorrow night is authorization to issue the bonds and to appoint a trustee of the bonds and to approve the second supplemental indenture, various other actions. So once the board does that, then it'll set in motion various activities of the bond council and the financial advisor. Then it gets to a point where they have to issue the notice of sale, they have to issue the official statement, the preliminary official statement, but they can't do that because the key component of the official statement is your guys' resolution. Not your resolution, but your disclosure documents. So without having the raw slide disclosure document, we can't begin that last piece of the process of issuing the notice of sale and all the other related bond documents. So there's activities we can do to get to that point in time, but then we're going to be a holding pattern if the board doesn't approve
The resolution.
the resolution, which then would approve the disclosures, which we.
Can we move up our regular meeting?
What, Pam?
Can we move up our regular meeting?
Certainly. I mean, they have to be a special
Well, I
meeting.
don't want to do
Nice.
I'd rather just move it up.
Let's keep it where it is.
My question was, if we approve it on the 18th, we're not holding up the process.
Mary, that's your question.
There's a schedule in that agenda packet there that great to take a look at.
Yeah,
What is the bond sale date? That's the key point.
The competitive bond sale date is March 18th.
So we'll hold it up on this.
Is that?
According to bond council, they could be ready to send the documents out. So if you approve it one night, then we would call them that night and say it's approved, and then they can issue everything next morning. That's my understanding.
So one day, could be one day.
Okay, now,
No,
without
it could be more than that, because they didn't notice. Okay, so we've got a motion and a second on the table.
Is Christian still on the line?
Christian? They're all
All right, I'll go.
Jolie? Oh, Christian.
Oh,
Yeah,
okay.
Frank has a question for Christian.
So how quickly can we get together with you, either you or Tom or Andrea, or whoever we're gonna get together with, and work on some language? Can we do this towards the end of the week or tomorrow or the next day? I mean, I don't know, all our schedules are really tight, but I think we're gonna squeeze this in.
We could also do a teleconference. I mean, I think it's a matter of language, so we don't have to physically do.
Tomorrow I could not, I don't know Tom's schedule.
Thursday?
All right, it's workable though.
You guys can.
Let's get it worked out. I mean, it's much easier to do this face to face rather than on the phone.
All right, so there's a motion.
So there's a motion and a second. All in favor?
Aye.
Okay, it passes.
Thank you.
Ladies and gentlemen, now, lost in the shuffle is we're supposed to approve, that was all on attachment B, but I've got some corrections on attachment A, which I'll just give them to you, Jason, some checkpoints and things like that. Sure. Yeah. There is some facts that are nothing important, but just you want to get right. Okay, anything else on item 4?
Just a quick question, and this is kind of like housekeeping here. And does our reso have to match CMSA's reso?
Well, it doesn't now. It doesn't now. So they're going to do their thing. We're going to do our thing.
Okay, I just want to make sure that's not a problem to hold it up.
Your resolution is specific to your disclosure documents. Our resolution
Okay,
doesn't
so would not be
have
able
no relation to your disclosure
Yeah,
documents.
haven't done this. Done.
Okay.
First agenda.
A question from the back before we adjourn to close
Yes.
session.
Yeah, the changes that you make, will they be available?
What, Mike?
Yes.
The changes?
You mean to a resolution?
No, you're making changes with Jason. You're correcting things that are in there that we have. I'd like to see a corrected thing after you finish with it.
Jason can show.
Good,
They're trivial.
good.
Okay, anything else on item 4? Okay, we're done with item 4. Should we take a break for a second?
Yes, please.
Yes, and thank you for being here.